So in December 2022, the government put a renewed focus on tackling illegal migration, and as part of this, one of the focuses was on tackling illegal working. So the government have put a 5-step plan in place, and one of these things was to make more resources available so that more immigration raids and immigration enforcement action can actually take place. This has been reflected in practice with the Home Office increasing their illegal working enforcement action significantly since the start of 2023. So given this renewed focus, Shabana, how important and what obligations do employers have in terms of looking at illegal working?
So all employers need to be aware that there is a legal obligation on all employers to ensure that they only employ individuals who have the legal right to work in the UK. And the way they do that is by doing a right to work check, which complies with very specific requirements of the Home Office to check that the person has the right to work in the UK to work in the particular role that they are going to be employed in.
And so why is it important that employers do these checks?
Well, the main reason it's important is because if they don't do the checks in the prescribed manner, and if it turns out that the individual doesn't have the legal right to work in the UK, then the employer is liable to civil penalties, which are up to £20,000 per illegal worker. So if you imagine if an organisation has a number of illegal workers, that figure can soon tot up. So that's the first key reason, is to avoid these civil penalties. If you do a check which is in the compliant manner, you obtain what is known as a statutory excuse against the civil penalties. So you're immune from the civil penalties, even if it does transpire that the person is an illegal worker because, for example, they've produced a document which was a forgery, but it wasn't an obvious forgery. The other reason why it's really important is that if you do receive an illegal working penalty as an employer, the Home Office issues quarterly reports in which they name and shame organisations that have been issued a penalty for illegal working. And that can obviously have knock-on implications for reputational damage, but also in terms of existing contracts with clients or bidding for future contracts with clients. If as part of that you have to declare that you have penalties for illegal working, that could impact on your ability to gain contracts or potentially even lose contracts with certain clients. The other reason it's really important is if you have a sponsor license. So if you are an organisation that has a sponsor license, which enables you to bring migrant workers into the UK for work, one of the conditions of having the license is that you will comply with all employment and immigration laws in the UK. And in particular with regards to the legislation around checking that you have that you are conducting compliant right to work checks. And if you do receive a penalty for illegal working, that could result in the revocation of your sponsor license, ending your ability to continue sponsoring any existing migrant workers or to sponsor new migrant workers, which obviously could have a catastrophic impact on on resources and operations, depending on how many sponsored workers you have and what roles they're in. But also, if you don't yet have a license but find that you need to apply for one, there is then generally a moratorium on being able to apply for a sponsor license within a 12-month period of having received and paid an illegal working penalty. So there are some quite serious implications and some very good reasons to ensure that you are complying with the correct right to work checks.
So what should employers be doing?
The key thing to be doing is to make sure that you implement and then operate a right to work policy which complies with the Home Office requirements. And there are 4 broad steps to having a correct process in place. The first step is to ensure that you obtain the correct document or do an online right to work check on the individual depending on their nationality and what the requirements are. Secondly, you must then check the document or the online check against the individual to make sure it is actually a check that belongs to the individual or a document that belongs to the individual. And when you're doing a manual check, as opposed to an online check, you need to ensure that the document looks like it's genuine and that it genuinely belongs to the person who's presenting it. The third key thing and the third step is to ensure that you take a record of the check that's been done and that you retain that record securely for the duration of employment and 2 years after the employment has terminated. And And the final stage is where you do a check on somebody who does have a time-limited right to work. You need to make sure that you're diarising when that right to work expires, so that you make sure you do a follow-up check in order to retain the statutory excuse and the defence against civil penalties.
Okay, and so if people are hearing this now and are worried that maybe they've not done this correctly in the past, what sort of things can we be looking to do?
If you're not sure that historically you've been compliant, and let's be frank, a lot of organisations haven't been compliant, partly because often the right to work regime hasn't always been at the forefront, because historically there hasn't always been the teeth behind it in terms of enforcement, which is now changing. But if you do have concerns, and I think the key thing to do is an audit of the right to work compliance across your organisation, and that will look different depending on the type of organisation and the number of employees you have, in terms of whether you check everybody or whether you do a sample of checks to begin with. But do an audit, check to see what records have historically been kept, and where records haven't been kept correctly, or where there are no records on file for a particular individual, ask individuals to bring in evidence of their right to work now. Obviously, conducting such an audit comes with a number of health warnings. And that includes things like ensure you are not discriminatory in the way you conduct the audit. So don't try to assess who you think might be a higher risk by virtue of appearances or names or accents or anything like that. Do the check indiscriminately against everyone within the organisation, or against an indiscriminate sample within the organisation. If you do come across somebody who doesn't have the correct right to work documents on file, I would suggest taking legal advice bespoke to the circumstances in terms of what the next step should be. Because although from an immigration perspective, the natural instinct might be to say, well, if you haven't got documents and you can't bring them in, we will terminate your employment. There are also employment law considerations to think about in terms of ensuring a fair process has been followed, and that you've articulated the reason why you might be thinking about terminating employment if it gets to that stage. So always take legal advice before doing that.
Brilliant, thank you. If you'd like any further information on the points that we've discussed, please feel free to contact myself or Shabana on the contact details that you can see on your screen, or you can find our details on the Walker Morris website.